Goodbye.
With your Lordship's permission,
Yes,
Lordship, I'd like to
Hey,
withdraw item number 4, part 2.
Item number?
Item number 4, part 2.
Yes.
Your Lordship, this is an appeal arising out of the judgment and order in civil suit number 3 of 2011,
Yes.
by which, Your Lordship, the learned trial court was of the view that the trial court did not have a jurisdiction because of the fact that it has...
Item 4 was fixed today.
Yes, it has been fixed today.
Yes, let's have it. We'll do it as a first hearing matter.
I have the impression that we may be allowed to approach a writ court.
You may.
May be allowed to approach a writ court.
You want to withdraw?
Yes, Your Lordship.
Oh, you want to withdraw this case?
Withdraw with liberty to file writ petition. Because it is a case where the land acquisition matter, where land acquisition is involved.
You may withdraw, but you are the appellant.
I am the appellant.
Here, if I had a look at the file yesterday.
Right.
Now, those additional trees, the teak trees,
Yes, yes.
they were not part of the first award, isn't it?
That's why we have come.
It was not part of that award,
That's true.
but it came out in that commission's report.
Yes.
Now, if that be so, then how Section 9 is barred?
Since that is the land itself, part of that land has been acquired, and part of the
No, what I'm
tree has
trying
been
to say
assessed.
is, I mean, if you want to withdraw, I shall allow it. But I was thinking perhaps you have a case, in the sense, it appears that the trial court has dismissed your case on the basis of no jurisdiction. Section 9 bar.
Yes, yes.
Now, that finding is arrived on the basis that the additional teak trees were part of the award. But is that correct? Because I don't think the other side have taken that plea that it is part of that award, because it came out subsequent because of that commission's report.
Yes, on the basis of commission.
And it was omitted. Isn't it?
That's true.
Have I understood it correctly?
That's correct, yes. That's it.
So I was thinking maybe, but anyway, if you are withdrawing it, I'll withdraw. I'll allow it right now.
Now Your Lordship is making me to sit on the fence.
No, because the matter was specifically fixed today, so there was nothing to do. So I had a look, cursory look, but of course I cannot tell you what I'm going to do because I'm yet to hear the other side.
That's
But
true.
that's the impression I felt, because whatever limited I read, it appeared that the only reason the trial court said that it lacks jurisdiction is because that particular that amount, according to the trial court, is part of that award 3 of something, right? Isn't it?
Yes.
So, but that award is not of that additional teak. This came subsequently by that commission. They found, I think.
Commission's report.
So, Mr. Lalram Zwaba, if you wish, you may wait for the turn to come. You think once again,
All right.
and maybe at that appropriate time, you may take a call if you want to withdraw, or if you still want to withdraw right now, I'll pass the order. Whatever.
Since Your Lordship has spoken out this opinion, Lordship, I feel it may be better to make a try.
Correct. If we find that, then you may withdraw it. Just wait for some time.
All right.
Let me
Yes.
finish the first one matters.
All right.
Okay.
Okay.
And anyways, you have a look at what I have just said.
Yes, yes.
Please find that out if I'm correct or not. Because this is my impression. I don't think that award 3 contains particularly of that re-added teak trees. That was an omission. Now that is an omission on their part. That can't be part of that award. Section 9 only talks about what is there in the award. And that is what is barred, according to me. Not something which is not there. So, okay.
All right.
You have a look at it, huh?
Yes.
Yes, please call the list.
Daily list for admission, item number 1.
My
Yes,
lord.
Mr. Lalfaxwala, this is yesterday's contempt?
Yes, my
Yes,
lord.
my lord.
Yes, Ms. Sangpui, what happened?
My lord, I received instruction from respondent number 7.
Is he engaging you? Mr. Mehdi, are you appearing in item 1? I cannot hear you.
My lord, item 1,
Are you appearing?
contempt 8 of 2022.
Yeah, no. Item 1 is contempt case of 21.
25 of 21.
25 of 21.
25 of 21, actually I have not.
Okay, very
My
well.
lord.
Because I saw you on screen, so I thought maybe you are also.
Yes. My item is item 2.
Mr. Lalfaxwala, this instruction seems to be a positive instruction,
There's new development, I think. my
I
lord.
think.
Yes, my lord.
So I think we'll wait for some time.
Yes, my lord, for filing my power also.
You file in the meantime.
my lord.
Okay?
In the meantime, if your lordship may allow me to take back, all right.
Ms. Angpui can,
She
Yes,
can
my
take it
lord.
from
she
the
can
registry.
take it. Let registry give the unserved notice. Mr. Roshan, na? You are appearing for someone? Okay. Where is yesterday's order? Yes, I got it. Heard Mr. C. Lalfaxwala, learned counsel appearing for the petitioners. Also heard MS Sangpui, learned CGC, appearing for respondent number 7.
Yes,
And Mr. R. Subedi, learned counsel, appearing for respondent stroke contender numbers 4, 5, and 6. In view of yesterday's order, I-112-2025, MS Sangpui has received instruction from the respondent stroke contender number 7 to represent him in the present contempt proceeding. Further, she has been instructed that the file, in order to get the opinion of the learned Attorney General AS on the matter, is in process. Relist the matter after 3 weeks on a date to be fixed by the registry to enable MS Sangpui file power in the matter. Let a specific affidavit be also placed on record on behalf of the respondent stroke contender number 7 by the next date of listing. In the meantime, let registry furnish a copy of the unserved notice of the respondent number 7 to MS Sangpui to enable her to communicate the same to the respondent number 7 in order to get the parawise comments in the matter.
Obliged.
My lord,
A copy of the letter dated 1/12/2025 placed by MS Sangpui in this regard is placed on record and marked as so and
My
so.
lord, if I may, the copy of the contempt petition may also be furnished.
I think in that notice everything will be there. You may say along with copy of the contempt petition. You serve it, Mr. Lalfaxwala?
yeah, definitely, my lord.
Huh?
Definitely, my lord.
So then
Because there is one unserved notice which has come back
this,
from respondent.
open that. We can open it.
My lord, with your lordship permission, can it be added that pendency of this contempt proceeding shall not be a bar for the petitioners to receive their compensation, my lord?
Why you need that? Open it. All right. So this does not have the copies of the contempt petition. Extra copies to be served by so and so, huh?
I'll give it to her, my lord.
You give it to her.
Obliged.
Item 2.
My lord, hello, my lord.
Yes, Mr. Mehdi.
My lord,
you
in
are-
this case,
I can hear you, but I cannot see you in the screen.
Yes, my lord, from there it is blocked.
Huh?
Something
Nobody's
when it
blocked
is-
you.
My lord, My lord, something is wrong, my lord. My junior is there, my lord.
You are appearing? Yes, what is your stand?
My lord, here, my lord, this,
Yes, Ms.
as per the
Valentina?
order.
This
My-
contempt is against?
My lord, on the last court date, my learned friend submitted that review petition 257 of 2025 was filed before the principal bench. The said review petition was dismissed, my lord.
Review is dismissed.
Yes, my lord.
My lord, I'm reading the review petition, the order, my lord. My lord,
One
My
second,
lord.
Mr. Mehdi.
my lord. My lord.
In the review, Ms. Valentina, there is in para 6 it says the directions passed by this court in the impugned order 19.3 has already been complied with.
With respect
Yes.
to the verification, my lord. However, the assessment was made and the amount to be received by me has not been paid, my lord.
Amount
My
is
lord,
still
my lord,
not paid.
may I,
My lord. It has not been paid to me till date.
my lord, may I submit, my lord?
Yes.
My lord, what happened in this case, my lord, there is a direction from the in main writ petition, my lord, that to verify and make assessment, my lord. And in the said petition, my lord, the petitioner along with wife was the wife, my lord. The land belongs to wife also. He stated his land, my lord, and directed to verify that land also, my lord. So
Have
it
you
is clear.
filed your affidavit, Mr. Mehdi?
Yes, I filed, my lord. And in the meantime, my lord, as per the last review petition, my lord, the order, my lord, this one, which my from learned friend submit before this honorable court, my lord. Accordingly, we filed another review petition before yesterday, my lord. It is numbered review petition 4 of 2005, my lord, regarding the assessment, which was assessed by the DC, my lord. That was wrong, my lord. In earlier, we filed a writ petition. It was dismissed because of pending of the contempt petition, my lord.
So
So
right-
we filed.
Right now, one more review is pending.
Yesterday we filed, my lord. Yesterday
you
petition.
filed.
Yes, my lord.
All right,
This-
Ms. Valentina, we will have this matter posted after 2 weeks. In the meantime, you find out what is that review.
My lord, one clarification I need from my learned friend, whether the review petition was filed against the judgment and order passed in WPC 148 of 2019 or another writ petition filed by themselves. Because
Yes,
it
my
will
lord,
be
my-
an entirely different premises, my lord.
Which is the order against which you are? Where do I find that order?
My lord, they are lordship.
Mr. Mehdi, can you please keep quiet for a second?
Yes,
It is
yes,
very
my lord.
difficult to hear. I am communicating here with the counsel of the petitioner. Please be
Yes, my
mindful
lord.
of what is happening in the court.
Yes, my lord.
Yes, Ms. Valentina, where do I find that?
The review petition newly filed by the learned counsel, is it against the judgment and order passed in WPC?
Before that, can you just read the operating part of the order of 19/3/2020? That is the order against which you are complaining non-compliance.
Yes, my lord.
Can you please read the operating part? I think it is extracted in your contempt petition at page 3, right?
Yes, and yes, my lord, the judgment, the operative portion is at page number 14, my lord.
Page number
14, 1-4.
14. Please
No,
read
no,
it.
sorry, 1-3, 13.
Yes.
From the second last paragraph, Mr. Ali Hussain, the learned counsel for the respondent number 2, submits that he has no objection to the prayer made by the petitioner's counsel. However, at the time of verification, the NF Railway should be represented in the verification team. In view of the consent of the parties, this court is of the view that a verification team should be constituted. Accordingly, the Secretary to Government of Mizoram Land Revenue and Settlement Department shall constitute a verification team consisting of the district collector cum deputy commissioner, Kolasip or his representatives, the deputy chief engineer, construction, NF Railway, Silchar, Kachar, Assam or his representative, and the petitioner, who shall verify the lands of the petitioner within a period of 1 month from the date of the receipt of a copy of this order. The verification team consisting of the above shall verify whether the lands of the petitioner have been used by the respondent number 2 for constructing a road. If the answer to the above is found to be affirmative, the respondent number 2 shall immediately take a decision within 2 weeks from the date of the site verification as to whether they want to permanently acquire the lands. If the answer is in affirmative, they shall make a requisition to the respondent number 1 and 3 for acquisition of the lands. Thereafter, award shall be made as per the Right to Fair Compensation and Transparency in Land Acquisition, Rehabilitation and Resettlement Act 2013 within a further period of 2 months. In the event the respondent number 2 is not willing to acquire the lands, the respondent number 2 shall stop using the petitioner's land immediately. In the event the respondent number 1 shall shall verify and assess the damage caused to the petitioner's land within a month from the decision taken by the respondent number 2, and the amount so computed by the respondent number 1 shall be paid by the respondent number 2 to the petitioner within a further period of 1 month from the date of the assessment made by the district collector cum deputy commissioner concerned. The writ petition is
So
accordingly disposed
the
of.
verification is done.
My lord, verification had been done on 4 occasions.
Now, after the verification, has it been found that the petitioner's land damage has been caused?
Yes, my lord. As per the findings made by the deputy commissioner and his representative, it was found that the land has been encroached by the NF Railways. Thereafter, assessment was made for the land and compensation.
Computed.
Yes, computed. Amount of compensation awarded to be given by the respondent number 2 is on page number 51 of my petition, my lord, 51 and 52.
50?
1 and 52.
Fifty-one of your petition.
My lord.
There's no 51.
This additional affidavit, probably. Maybe my additional affidavit, my lord.
One in my contempt petition, my lord.
Spot verification report.
No, page 51 of my contempt petition, my lord.
There is no page 51 in your contempt petition. Where is the contempt?
Sorry, my lord, 19.
Huh?
19, page number 19.
Page number 19.
Yes.
Yes. Annexure 5.
Annexion number 5, this one is for the petitioner, period Pata number 58 of 2005, and amount computed is 48,42,000.
Yes.
And at page number 20,
Yes.
this is for the periodic Pata 59 of 2005 belonging to the wife of the petitioner, amounting to 3,22,800.
Yes. This has not been paid.
This has not been paid till date.
Yes. Mr. Mehdi, why this has not been paid?
My lord, Lordship may produce ordered at 17/6/2025 in contempt petition, my lord.
17?
17 June 2025. I'm reading, my lord.
Yes.
Learned Counsel for Respondent 5 submit that the court that the court in order dated 19/3/2020 passed WBC number 148 of 2019 has not specified the periodic passes which are to be verified by the verification team, and submitted that since periodic pass number 59 2025 is not in the name of the petitioner, they would have to like to file a review petition before the concerned bench. Now, he therefore prayed to file a review petition before the concerned bench. In Learned Counsel further submit that no objection was already obtained by the Deputy Commissioner on 6 February 2025 With this land was, my lord, this purchased in 2018, but no eviction was, my lord, given 2018, 15, my lord. Would like to
I
place
cannot
the fact-
understand anything that you say, Mr. Medhi.
My lord, what happened, my lord? The writ petition was filed by.
I don't know, but can you all understand? I feel
My
the
lord-
network is very disturbing. Yes, what is your senior saying? You can understand?
Yes, yes.
What is he saying?
After the order dated, order passed in writ petition number 148/2020, thereafter joint verification was conducted. Thereafter we came to know that there are two lands of two periodic patta. Both the lands are not of the petitioner,
Okay.
one of his wife. And so thereafter we filed one writ petition in the year 2024, WPC number 112,
Yes.
2024, challenging the joint verification report and the consequent assessment
That
made by-
is at page 19,
Ye-
correct? Which we just read. So this has been challenged by you in a writ petition,
Yes, yes.
right?
Thereafter, on 17 June 2025,
Yes.
the order is given to your lordship. The learned single judge dismissed the writ petition, repeat WBC number 112/2024. And in the order dated 17 June 2025, passed in contempt case number 8 of 22, it is reflected that the Honorable Court give liberty to
File a review petition.
Yes.
So that
Thereafter we
review,
approach
that review you have filed.
Yes.
Now that review is also, it seems to have been disposed of by saying
That
that you
review
have
is
already
dismissed.
complied and
Yes.
nothing to review.
Yes, Lordship
Yes.
may have a look at the order of the review petition.
Paragraph 6,
In paragraph number 5, Lordship,
yes,
may I read, Lordship?
yes, please.
The review petitioner had put to challenge the assessment of damages payable to the petitioner and his wife made by the district collector by way of WBC 112/2024. However, WBC 112/2024 was dismissed by a coordinate bench of this court on the ground that the alleged non-compliance of the impugned order dated 19th March 2020, passed in WBC number 148/2019, and the verification reports, etc., were issues in contempt case number 8 of 22. Further, in contempt case number 8 of 22, the court had given liberty to the review petitioner herein to file the present review petition. Now, Lordship, paragraph number 6, on considering the fact that the directions passed by the court in the impugned order dated 19 March 2020, passed in WBC number 148/2019, has already been complied with, there is nothing to be reviewed. If the review petitioner is not happy with the verification report and the
So have
contents
you
therein-
filed a writ petition challenging the verification report?
Yes, but we had already filed WBC number 112/2020.
That is over. You see, Mr. Counsel, the 112 you have filed,
Yes.
an
again-
order has been given in 112.
Yes.
That order is the order of 19/3/2020,
Yes.
correct?
Yes.
Against that order, because that order says now you verify, spot verification, after that you pay.
Yes.
This is the order of 19/3/2020 passed
Yes.
in WPC 148.
Yes.
Right?
Yes.
Now, that you have not, after that was done, you file another writ petition because
Yes.
that's spot verification.
Because railway is not.
Correct.
Yes.
That was WPC 112 of 2024.
Yes.
Now, in that WPC 1124, you filed a review petition.
Yes.
That review petition is also now dismissed.
No, my lord, no, my lord,
No,
that is
no,
not, my lord.
No,
We-
against
we
the
put-
order dated 19th March 2020, we filed review petition.
Present
Okay,
petition,
so
present
this
review.
112 is filed by your wife. The review
No.
petitioner has put to challenge the assessment of damages payable to the petitioner and his wife made by district collector by way of WPC 112/2024.
112
However,
is filed by railway.
112 was dismissed
Yes.
on the ground that the alleged non-compliance and the verifications were issued. So that 112 is already dismissed.
My lord, on 112, my lord, we file review, present review petition, my lord.
No, that we are
We-
not concerned.
My lord, the present, this, which,
We are
my
not
lord, just,
concerned with all that. What about
My
the
lord-
assessment? There is an order. Is there
My
any
lord-
stay order, Mr. Medhi? Where
My-
is the
no,
stay
my-
order?
My lord, this was reflected in the review petition which was filed before the order of the Honorable Justice Michael Jothang. That order, my lord, it was reflected, my lord. This we challenged the said assessment, my lord, on the WPC 112/2024.
I have understood, I have seen
So-
it,
so-
but that is
so-
already dismissed.
Yes, my lord. And according to my lord, this present contempt, which was contempt, it was already complied with. It is reflected in paragraph 6. So if lordship allow my lord, physically, I argue this matter on after vacation, my lord. If lordship allow my lord.
Yes, please take down. Heard MS Valentina, Lalanpui, Learned Counsel for the petitioner. Also heard Mr. S.K. Mehdi and Mr.
KK Mehdi.
A.K.
KK.
K.K. Mehdi, Learned Counsels appearing for respondent stroke contemptor numbers.
Five.
Number
Five.
5. MS Valentina so and so submits that the review petition 257 of 2025 seeking review of the order dated 19/3/2020 passed by this court in WPC 148 of 2019, non-compliance of which is the subject matter in the present contempt proceeding has been dismissed by the review court by order dated 13/11/2025. She accordingly submits that despite the spot verification having been completed and an amount of rupees 4,842,000 and rupees 3,22,800 being computed against the petitioner and his wife respectively, the said amount has not been paid to the petitioner and his wife in gross violation of the judgment in order dated 19 so and so passed by this court. These figures, Dekha, you will get at page 19 and 20. And the reference of that case, 19, that you will get at page 12. That is the order complaint. Okay. On the other hand, Mr. S.K. Mehdi, Learned Counsel, appearing for the contender number 5, submits that the respondent, being aggrieved by the spot verification, has challenged the same before this court in WPC 112/2024. However, the same having been dismissed by a coordinate bench of this court, a review against the said order has also been filed yesterday.
Well, yes, my lord. Yesterday, my lord.
Filed yesterday before this court.
Yes, my lord.
Bef-
Review
before-
petition
Before
4 of
this
20.
court being review petition number
4 of 25.
4 of
25.
2025. It prima facie appears that despite the order of this court way back in 19/3/2020, directing the respondent number 1 to verify and assess the damage caused to the petitioner's land within a month from the decision taken by the respondent number 2 as regards use of the land of the petitioner for construction of a land, for constructing the land in question, to compute the amount against the damage caused to the petitioner's land and pay the same by the respondent number 2 to the petitioner within a further period of 1 month from the date of assessment made by the district collector cum deputy commissioner concerned. It further appears that despite the district collector cum deputy commissioner having made the assessment, the payment has not yet been made to the petitioner. There appears no stay of the aforesaid direction passed by this court at any relevant point of time. That being so, prima facie, the respondent appears to have acted, have not complied with the directions of this court. Be that as it may, list the matter for hearing in the month of February 2026 on a day.
January, please, my
You
lord.
want it in the January?
My lord.
When is your court
But-
opening?
22nd January, my lord.
Okay, on 22nd January, so and so. And it is needless to be clarified that filing of a review against the judgment and order passed in WPC 122 of so and so
112,
112 of
2024,
2025,
4.
24, a mere filing of review is not sufficient ground for non-compliance of judicial order passed by this court.
Much obliged.
Item 3.
Highly obliged.
That, please verify that numbers. That 122 is reflected in that order.
My lord.
Yes, Miss Jacinta, right?
Yes, my lord.
Yes.
In the
What
last
is
court,
this matter? Yes.
my lord, I'm here on behalf of Miss Mary L. Kyangte, and she has some personal difficulties.
Today?
Yes, my lord.
All right. As prayed for on behalf of MS Mary by Miss MS
It's
so and so,
Deborah.
relist after a week.
After vacation, my lord.
After the ensuing vacation.
After the ensuing vacation on a date to be fixed by the registry. Please mark presence of MS Jacinta also for the petitioner.
Much obliged.
Item 4.
Yes, Ms. Valentina.
May it pleases your lordship, we have impleted the respondent number 16. Steps for notice was taken on 31/10 of 2025. AD card from the said respondent number 16 newly impleted has not returned yet, my lord.
Okay, await service in respect of the newly impleted respondent stroke contempt number 16. Marked presence of Valentina and you're from MS Mary? And so on. Yes.
Obliged.
Item 5.
Please give your respondent contempt numbers. Take their appearance. Yes, Ms. Jacinta.
My lord, I have received the affidavit in opposition filed by the state respondent.
You want to file a rejoinder?
Yes, I want to file rejoinder against the
Okay.
affidavit for the respondent.
As prayed for by MS Jacinta, Learned Counsel appearing for the petitioner, relist the matter after 2 weeks
Yes, my
on a
lord.
date to be fixed by the registry to enable the petitioner file a rejoinder to the reply affidavit file on behalf of respondent numbers.
Respondent number 4 and 1 to state respondent. There is true affidavit in opposition.
Okay,
Yes,
two affidavit, rejoinder against the 2 affidavits filed by respondent number 4 and
state respondents.
state respondents respectively.
Malon, I'm appearing for the respondent number 4.
Give the presence of all the counsels.
Much obliged.
Item 6.
Yes, Mr. Victor.
Yes, Your Lordship. In this matter, I have instruction to represent the respondent number 3.
3. But what about 1 and 6? Anyone appearing for 1 and 6? Because the unserved notice has not come back from respondents 1 and 3 to 6 till date. Now you are saying you will appear for 3. Ms.
Yes,
Vani?
Your Lordship.
And you are appearing for?
Miss Mary will be appearing for respondent number 4.
4. So 3 and 4 we have. I think we'll have to wait then.
Yes, my
Mr.
lord.
Victor. Heard Mr. Victor Lalte, Learned Counsel, appearing for the petitioner. Also heard MS Vani, Learned Counsel, who has entered appearance on behalf of the respondent, contemporary number 3.
Yes, Your Lordship.
Also heard MS
H.C. Deborah.
so and so Learned Counsel, who has also entered appearance on behalf of respondent number 4. Make it together. Huh? Also heard so and so who have entered respectively. However, service in respect of respondent numbers 1, 2, 5 and 6 is still awaited.
True, yes.
Huh?
1, 5 and 6, my lord.
2 is received? No, okay. So what is awaited? 1,
1, 5 and 6.
1, 5 and 6 is awaited, and before that Dika say that though service in respect of 2 is complete. What has come back? Show me. This has been served. Served, no signature. It appears from the AD card returned back in stroke contemner number 2 that the notice has been duly served upon the said contemner. However, there is no representation on behalf of respondent number 2 today on call. Did I say relist? After 2-3 weeks.
I'm obliged.
2-3 weeks, whatever, you give a relist. Yes. All right, Mr. Victor.
Item 7.
My lord, I had taken steps upon the respondent number 3.
Yes, Mr. Klianga.
However, I had taken steps upon the respondent number 3. But however, it had come back
Awaiting-
unserved, my lord.
Answer.
Yes.
Office
There's
note has come.
office note has come, my lord. It's a insufficient address.
So
So,
what
if I
to
may
do?
be given a week's time to ascertain the precise address of
Heard
the
Mr. Klianga, Learned Counsel appearing for the petitioner. Also heard MS Vani for Learned APP for respondent numbers 1,
1 and 2.
1 and 2.
1 and 2. It appears from the office note that the notice in respect of respondent number 3 has come back due to insufficient address. Mr. Klianga requests a short accommodation to furnish the correct address. Prayer is allowed. Relist after 2 weeks on a date to be fixed by
My
the
lord, if the interim may continue, my lord.
interim, if any, shall continue till the next date of listing.
And my lord, if I may be allowed to take back the unserved petition, my lord, from the registry,
That you take back.
my lord. I'm obliged.
He may be allowed, needless to be clarified that that the unserved copy of the notice, in the event a request is made to take back the unserved copy of the notice, the same shall be handed over to so and so by the registry of this court.
I'm obliged.
For orders, item 8.
Am I being very fast? You can manage. Yes, Mr. Victor, what is this bail?
Yes, my lord. The petitioner was arrested on
22C.
22C, my lord.
Ms. Vani, you are there?
My lord, the petitioner was arrested on 31/01/2020 in connection with this special narcotic case number 6 of 2020 under section 22C NDNPS Act 1985, wherein suspected methamphetamine weighing about 27 kgs was seized. And my lord, after the petitioner was arrested, my lord, he was released on bail on 7/4/2020, and thereafter, my lord, he was remanded back and rearrested on 23/4/2025. 23/4/2025. Thereafter, my lord, now the trial has just begun, and PW1 was already examined and cross-examined. But at present, my lord, the petitioner is hospitalized due to knee surgery, ACL tear of left knee, and he had undergone surgery on 11th of November, and he's still hospitalized, my lord, at present.
How long he has been in custody?
Now, my lord, counting from the arrest, my lord, April.
Not much.
Not
This
much,
is
my lord.
Because you see, 37 is there.
That is correct, my lord. But at the same
Then-
time, my lord, from the evidence so far, there is reasonable ground to believe that he is innocent of
Only
the
one evidence
accusation,
taken?
my lord. Yes, my lord.
How many
The other-
total? How many evidence?
6, my lord.
Out of 6, only one evidence has been taken. PW1.
Yes, my lord.
How can at this stage we form that
My lord.
reasonable ground that you are not involved?
My lord, there is violation of the constitutional mandate of Article 22(1) of the Constitution, my lord.
What has been violated?
He has not been informed the ground of his arrest in any manner, my lord, either by way of writing or orally, my lord.
Have you taken this ground?
Yes, my lord, I have taken that ground, and he had earlier approached the trial court twice prior to coming to approach this court, my lord. And both the bail applications were rejected on the ground that although there's a ruling of the Supreme Court in that regard that this is constitutional mandate,
Vihan Kumar.
in the trial court, my lord, the applicant was relying upon the case of Pankaj Bansal and Prabir
Purkasta.
Yes, my lord. And
Now we have Mihir Shah.
yes, my lord.
Are you carrying Mihir Shah or not?
Yes, my lord.
Hey, Deka, I won that yesterday's bail matter. So you are alleging 22(1) violation.
Yes, my lord.
So anything to show there was informed?
Yes, Your Lordship, on perusal of the rejection order, that is on dated 15/10/2025, Your Lordship.
Page?
That is in page 26 of the bail application. Para number 6, Your Lordship. If I may read out, Your
Yes,
Lordship.
please.
As for the grounds of arrest not being furnished to the accused petitioner in writing, the Honorable Guwahati High Court in bail application number so and so had rejected the bail application of the accused after considering all the relevant rulings of the apex court and of the High Court, on the grounds that it was not mandatory to intimate the grounds of arrest in writing to an accused prior to the pronouncement of the judgment in Prabir so and so, so long as the accused had been informed about his arrest at the time he was produced before the learned trial court in terms of Article 22(2) of the Constitution within a period of 24 hours of such arrest. The apex court in so and so, henceforth, the grounds of arrest must be communicated in writing to the accused. The same would be applicable only after the said decision was made on 3/10/2023.
Your
Thus,
case is different, Mr. Victor.
I'll come to that, my lord.
No, because it appears that this court has already considered all this.
yes, Your
Where is
Lordship.
that order?
My lord,
Where do I find this order? The order of this court in bail application 1100 of 2025.
this is different case.
This is an order passed by this court. I think this is that Manipur case. Where is this this application?
Versus.
At paragraph 6, an order has been referred. Where do I get that order?
And Your Lordship, in the same paragraph, in the last sentence, the arrest memo of the accused petitioner already exhibited in the
I-
court
I
showed
have seen.
under. So, Your Lordship, there is a compliance of Article 22(1) in the present case.
See, it says that in your case it was informed.
He was not informed, my lord.
From where are you showing?
My lord,
Now, but Ms. Vani, only thing, you see, once now they are saying that you have not informed, you show me the document from where I can satisfy myself that it has been informed. Which is that document?
Yes, Your Lordship.
And Mr. Victor, please ask your junior to find this case, which is mentioned at paragraph 6. I have a feeling this is that Manipur case, perhaps authored by this court itself. Because there was one paragraph in Purkasto and Bansal which says that written communication is only post those case laws, not prior. But nonetheless, information has to be given. So you see, Mr. Victor, what happened? Suppose the judicial order shows that so and so has been asked, have you been informed? And he said, the accused says yes. That is sufficient because he has been informed. What is required is the information. The writing has come after that decision of the Supreme Court. Now any arrest post that date, writing has to be there. But pre-arrest of that decision, if anything is there to show that he or she was informed, is sufficient compliance.
But my lord,
That is how perhaps that decision is. Please try and find out that decision. Arun Kundan Bam of the principal bench. I think this is my idea. Find out Corazon. Michael, just give this reference. That 6 is mentioned in paragraph 6. Can you take out online? It's from the principal bench. But yes, you take what you want to take.
Your Lordship, another thing is that he was produced before the CJM court.
Where are those?
I have submitted them, Your Lordship. So here the grounds have been narrated clearly.
So that means immediately he did know.
Yes, Your Lordship.
Where have you flagged it, Ms. Vani? Where is it? This is the CJM.
Yes, before the CJM, there is a
Please,
prayer.
can you flag the relevant pages?
Yes, Your Lordship.
my lord, I have found the judgment. It was rendered by your lordship.
That's why I remembered.
Dated
I think this is from that Manipur ethnic violence case.
dated 9/5/2025.
Give it to Michael.
9/5/2025. Bail application number 1100 of 2025. Principal seat.
Can you email it? Can he email it to you? You can take a print. Acha. You spoke with the library? Okay. There is a paragraph towards the end where I have specifically dealt with Prabir Purkasto and Bansal. See what happened, Mr. Victor, in that case, a ground was taken that they have not been informed. Okay. Now, when I had examined the trial court records, I found that at the time they were produced before the magistrate, that 24 hours production, they were asked. And they specifically said, yes, we are informed. So it amounted that they have been informed. And these arrests were prior to that cutoff date, from where the writing came. Because in 22(1), nowhere it says it has to be in writing. If you read Article 22(1), it doesn't say in writing.
That I understand, my lord.
Correct. So therefore, because there is another, in Vihan Kumar and subsequent cases, it has been clarified. The writing, that too in a language the accused has to understand, these has been added post that. So for arrest post that period, it is mandatory to be in writing. If the prosecution cannot show us that in writing the reasons have been given, the facts constituting the offense, a clear-cut violation is made. So, but for the period prior to that, information, if anything is shown, which indicates that, they were informed. See here, this is the production, 16/5, that's the production date.
Yes, Your Lordship.
Case record, accused informed the court about the, additional PP informed the court about the accused.
No, my lord,
court-
this is the second production after he absconded. He was absconded, and later on, the accused was arrested on different case.
No,
That,
but where can you show from here? I can't see.
This is the order sheet, Your Lordship.
Which is the order sheet?
The flapped one, Your Lordship. That
This
is-
one?
The order is 16/5,
Correct, please
2025.
read.
Case record is put up on call. Learned additional PP informed the court about the accused for whose arrest WA was issued is arrested in special narcotic case number 73, 2025 under section 22C on 23/4/2023. Your Lordship, he was rearrested on similar offense. He committed another offense while he is in bail, and moreover, he is absconded.
No, what is this said? What warrant of arrest was issued against the?
The standing warrant was issued against him, and prior to the standing warrant, he was arrested on different offense committed by him.
No, but Ms. Vani, you are still not answering what I am asking you. From where do you show that he was informed? Do you have the warrant of arrest?
No, my lord.
So
He was informed at the time of the first arrest in the arrest memo.
where is that
And,
arrest
Your
memo?
Lordship, I'm sorry that the scanned copy which I have received, I did not receive that arrest memo. But however,
Correct. That is what I'm asking. You have
Yes.
to place some document before this court, because there is one of the orders indicates that perhaps these informations are there. Now he is saying no, it is not there. Onus comes on you, because if you go by Mihir Shah and Vihan Kumar, in these decisions it is clearly held by the apex court that if a ground is taken by an accused that he has been he has not been informed of his constitutional statutory rights of information about the grounds of arrest, a clear-cut violation of his arrest is made out. Now, when such a plea is taken, the onus is on the prosecution to show that he has been informed, that the prosecution has complied with the constitutional mandate. Correct?
yes.
So
Your
you
Lordship.
place those documents before this court. I have not followed anything, because this is neither here nor there. It simply indicates that he was initially arrested, thereafter he was absconding, warrant of arrest has been also issued, and again he has been arrested. But whether that warrant indicates the grounds, whether in the initial time when he was arrested, whether the grounds were informed to him, all these informations are lacking.
Yes, Your Lordship. If the matter
You see,
may be-
Ms. Vani, have you understood what
I understand, Your Lordship.
So I can post this matter on another date.
Yes, Your Lordship.
You obtain all your instructions, you
Yes, Your
place them properly, because ultimately you see a liberty of a person is also at stake, right? Now, if suppose this court comes to a finding that 22(1) has been violated, then we cannot keep this person in custody for a day also. He
I
will have to
understand,
be
Your
released,
Lordship.
because there cannot be, isn't it? So you have a look at it.
Yes, Your Lordship. I
When
will
can
look
we have
into
this
it.
matter?
Even by tomorrow we can have, Your Lordship, because it is very clear that from the order of the trial court, there is the arrest
See,
memo. So,
I
will look
want
into
you to
that.
get me the information.
yes, I will look into that.
You look into the Caesar, trial court only refers to the Caesar and the arrest memo.
Yes.
But those are not placed before this court, because there are instances when the prosecution relies upon the arrest memo, and when the court has a look in the arrest memo, we find that except reference of the case, no facts constituting the grounds of arrest is mentioned. So we don't know in this case whether that has been done or not. We have to be fully satisfied.
Yes, Your Lordship.
Article 22(1) violation is being complained. It cannot be discharged so casually. merely referring to the observations of the trial court, isn't it?
Yes, sir.
Because there are instances, in fact, yesterday's case, Ms. Vani, if you remember,
Yes, Your Lordship.
the arrest memo only had a reference of 22C, nothing else. That is not sufficient compliance of 22(1).
I understand.
Relist. So tomorrow is division bench? But we can
Thursday,
have
Your
this.
Lordship, then.
We'll have it tomorrow.
Yes, my lord.
After the DB then.
Yes, Your
Okay.
Lordship.
Yes, my lord.
All right, relist tomorrow. Mr. Victor, you have a look at that decision.
I'll go through this. Yes.
You want a print?
I'll print out myself.
Huh? Or give him also a print. And one more print from you. Give it to Mr. Victor. You make a photo.
Deeply obliged.
And Mihir Shah also you keep.
Yes, my lord. And also one judgment of the Supreme Court.
The latest is Mihir Shah.
Besides that, my lord, Kanis Sinha, wherein the Honorable Apex Court held that the retrospective operation of the judgment, unless specifically mentioned that it should be prospective.
You get that also.
Yes, my lord.
Item 9.
May it please, Your Lordship.
Yes, Mr. Lalpa Kwama, what is
My
the
Lord, there's a
condonation?
slight delay of 169 days in filing the connect.
169,
Yes, Your Lordship. Basically,
Mr. Joseph is opposing you.
I'll leave it
Serious
to my.
objections.
My lord, there are only like 1 or 2 points, my lord, that we'd like to point out.
Yes, a condonation for filing what? RFA.
RFA, Your Lordship.
What is the grounds?
The grounds is basically is that the case was summarily dismissed on the grounds of limitation, and our main ground is that
Michael, can you open one of the windows? Can you open a window? It's getting into suffocation. I think the generator is on. no? Okay, it's getting a little. Yes. Okay, a little bit. Yes, please.
Yes, Your Lordship. So the case was summarily dismissed on the grounds of limitation. Now, our humble submission and our main ground is that in order for a civil suit to be dismissed on the ground of limitation, an issue has to be framed under Order 14, Rule 2. So that was not done. So unless there is a specific issue framed under
No,
Order
but
14.
for condonation, what are your grounds?
My ground is that, Your Lordship, the judgment in order was passed on 14/11/2024. I suffered a stroke in the month of June of 2024, prior to the judgment in order. So after that, Your Lordship, I have been bedridden. I have been in and out of hospital, and later on, it was found out that I had suffered gastrointestinal infection as well. So because of all those reasons, Your Lordship, I could not take a
Which
firm.
paragraph I find them?
Your Lordship will find that at page 3, para 2, sub-para 1 onwards.
Medical grounds. Yes,
Medical
Mr.
grounds,
Joseph,
Lordship.
what is the ground of objection?
Yes, my lord. Firstly, my lord, if your lordship will turn to page number 5, my lord, there paragraph number 5.
Yes.
Now, the starting of this paragraph is like this, my lord, that when the applicant number 1 regained his strength, my lord, this is how I understand, my lord, when he became well,
Yes.
he summoned his family members to his residence in the month of March 2025, and a joint family decision was taken to prefer an appeal against the order. Now, this was in March 2025.
Yes.
And the next incident we see is at paragraph number 6, my lord, that the applicants contacted their legal counsel in the month of April 2025. Now, this entire month between March and April, my lord,
That's all right.
does not seem to be explained, my lord.
It's all right, Mr.
Yes.
Joseph.
And my lord, there are
It
two.
not be a day-to-day explanation. His family, he requested, he was in the bed, he had a heart attack, a stroke, and he requested his family people to take care. This was done in March 25, and in April 25, they contacted legal counsels, the family members.
Yes, my lord. My lord, I mean, let me just raise my objections, my lord. My
Yes.
lordship can record my objections, my lord.
Yes,
And then that
yes.
paragraph number 6, my lord,
But
You'll-
don't object for the sake of objecting, because these are condonation matter ultimately, Mr. Joseph, and it's a discretion of the court.
Correct,
Unless and until there are reasons attributing that you know they have been deliberately sitting over with malafide intention.
Yes.
So otherwise, you see, condonation has to be looked into
Looked
liberally.
into. No, my
isn't
lord,
it?
my lord,
All right.
100% agree. My lord,
Please.
100% agree. My lord, just look at this. My lord, if your lordship will think this is not deliberate, then I will no objection. I'm
Yes,
just
please.
pointing out these facts, my
Yes,
lord.
yes, yes.
Now, my lord, paragraph number 6.
Yes, please.
Now, my lord, paragraph number 6, it is mentioned in the second sentence like this, that a date was fixed on 10/4/2025 and again on 17/4/2025. This was for the meeting with the council. However, on both the occasions, no discussion and or instructions could be made due to the sudden weakening of the applicant number 1. Now, the next incident mentioned, my lord, and there was no meeting after this. The applicant number 1 instructed his legal counsel through telephonic conversation on 16/5/2025. Now, I'm not very sure, my lord, if he had, there was no explanation has been no explanation between 17/4/25 to 16/5/25, which is almost 1 month, my lord. That is another point, just pointing out, my lord. And finally, my lord, one other point is there. They had instructed to appeal, and the instruction was received on 16/5/2025. My lord, in the next page, at page number 6, paragraph number 7. And if your lordship will see the last line, the last sentence, my lord. Accordingly certified through copy of the order dated 14/10/11/2024 was applied for by the council for the applicants on 26/5. So again, another 10 days wasted, my lord. I'm not sure what they were doing for those 10 days. And then finally, my lord, paragraph number 10 and paragraph number 11, my lord, if I may point out one other thing. My lord,
Yes.
they had mentioned that there was a summer vacation between 7 to 11, my lord. Now, after 7 to 11 summer vacation, my lord, another days were they had waited for some few more days, and then court fee was submitted in paragraph number 11 on 18/7/2025. My lord, these are the points I want to raise. So your lordship can make the decision, my lord.
All right. Heard Mr. Lalfakwama, Learned Counsel appearing for the applicant. Stop. Also heard Mr. Joseph Lalchinama. Right?
Lalchanhima, my lord.
Learned Counsel appearing for the respondent. By way of this application under Section 5 of the Limitation Act 1963, the applicant is seeking condonation of delay of 169 days in filing the connected regular first appeal against the order dated 14/11/2024 passed by the Court of Civil Judge Senior Division 1, Aizawl in money suit number 46 of 2020. Counsels, you may take your seat, please. The applicant, being aggrieved by the judgment and order dated 14/11/2024 passed by the Learned Trial Court in the money suit number 46 of 2020, preferred the accompanying regular first appeal. However, due to medical health condition of the applicant number 1, there was a delay of 169 days in filing the said regular first appeal. Accordingly, the present condonation application has been filed. Mr. Lalfakwama, Learned Counsel appearing for the applicant, submits that due to the applicant number 1 having suffered from stroke in the month of June 2024, and also he only suffered the gastrointestinal infection, or
Yes, Your Lordship. The applicant number 2 is my wife.
2 has suffered?
No, 1 has suffered.
And-
Applicant 2 is my wife.
and also having suffered from gastrointestinal infection, for which he was under constant medical care, the appeal could not be filed on time. He further submits that the delay having been occurred due to medical exigencies, the same is neither willful nor intentional, and hence the delay may kindly be condoned. And hence the explanation tendered for the aforesaid delay may kindly be accepted. Okay, change word. Per contra, Mr. Joseph so-and-so, learned counsel appearing for the respondent, while vehemently opposing the prayer for condoning the delay, submits that there has been no day-to-day explanation as regards the delay caused in filing the regular first appeal. He further submits that despite the applicant number 1 stating in the condonation application that he had summoned his family members to his residence in the month of March 2025 for having a decision in order to prefer the appeal. However, the applicants contacted their legal counsel only in the month of April 2025. He further submits that despite there being meetings in the month of April 2025, no decision till 16/5/2025 was taken by the applicant number 1 to instruct his legal counsel to go ahead with the appeal. He submits that the aforesaid clearly indicates that the applicants were not pursuing their right diligently, and hence the explanation is not sufficient enough for exercising the discretionary power of this court for condoning the said delay. Stop. Correct?
Yes, ma'am.
Having heard perused the Corridiba, it appears that the applicant number 1, upon having suffered stroke in the month of June 2024, and while he was under constant medical care, he also suffered gastro and liver problems, for which he had to constantly undergo medical treatment. It appears that though he had tried to discuss the matter with his family members after he took complete bed rest during the month of February 2025, a decision to file the appeal could only be taken in the month of April 2025. it appears that the explanation, this court, the explanation appears to be sufficient and bona fide. It appears that the replicant number 1, despite his medical condition, was making a fair attempt to pursue his family members, to assist him in preferring the appeal, and accordingly, ultimately, could prefer the appeal through his legal counsel. However, the delay of 169 days occurred. That being so, the delay is condoned. I stand allowed. RFA, you issue notice, call for the TCR. Huh? Only one respondent.
One respondent.
Yes.
Call for TCR.
Deeply obliged.
And list after 3 weeks.
3 weeks.
Item 10.
May it please your lordship. This is an application for condoning the delay of
How much delay, Mr. Joram Chana?
244 days, my lord.
200?
44 days.
Lal Fagwala is seriously objecting it.
No, I'm not yet representing the respondent
My
number
lord,
1.
for the first time. my
This is
lord.
the first time.
Oh.
This is,
So then notice has to go.
yes,
Yes,
my lord.
my lord.
I'll accept notice on behalf of respondent number 1.
Okay, notice are 1 Lal Fagwala, 2, 3, 4 registered post.
No, my lord, 4 if we can serve by way of Dusty because the address
2
mentioned
and
here
3
is
registered 2 and 3, 4 registered post, and Dusty also in case of 4 corridors.
Dusty 4. Yes,
I'll
my lord.
file my power within 3 days. my lord.
3 weeks.
Yes, ma'am.
Huh?
I'll file my power within 3
Yes,
days.
yes, yes.
Obliged, my lord.
Item 11.
Mr. Lalchin Liana, na?
My lord,
Condonation.
not condonation, my lord, this is a application for striking out of the respondent number 2 and 3 and in their place for addition of the 2 new incumbents.
This is for in a contempt or what?
Yes, in a contempt case.
Then
my
why
lord.
striking out?
My lord, during the, after filing of the
No,
contempt.
they may have left, but why striking out? We will allow you the impleadment, but why to strike out? We don't know.
My lord, after the
Mr.
filing of
Lalchin, Liana.
the instant case, the learned CGC representing the respondent number 5 has submitted a letter which is annexure 1, my lord, page 8. If your lordship may kindly see.
Yes.
Letter dated 26/8/2025 of the respondent number 5, whereby it was stated that the respondent number 2, Priya Kumar, is not holding the post of Director
No,
General.
it doesn't
News.
say it's not.
Hmm.
Is hold the post of Director General News, not Director General Doordarshan.
And the respondent number 3, Surendra Singh, hold the post of Deputy Director General Admin,
Not Deputy Director Administration.
So, upon this information being appraised by the learned CGC,
So you
I am allowed to.
Okay, understood.
Yes.
So you have initially impleaded Priya Kumar and Surender Singh,
As
but they are not the competent authorities.
My lord.
Now you want to strike them off
My
and
lord.
implead the competent authorities.
My lord.
Who are they?
For respondent number 2, Prasar,
So now you want
Satish-
Abhijit Majumdar and Om Prakash Tripathi.
my lord, no, my lord.
Huh?
K. Satish Nambu Diripat.
Where do I get their names?
In the prayer portion, my lord. Page number 6. And para number 6 and the prayer portion, my lord.
Yes.
We have done the verification. Then we found that Mr. K. Satish Nambudi Ripat is the Director General, who should be the respondent number 2. And Ramesh Singh Chauhan, Deputy Director Admin.
Okay. I'm allowing it, Sangpui. Heard Mr. Lalchan Liana, Learned Counsel, appearing for the applicant.
My lord.
Also heard M.A. Sangpui, Learned Counsel, appearing for respondent number 5. 5, Ms. Sangpui? 3.
No, 5, my lord. She is for respondent number 5.
Check.
3 and 5.
3 and 5?
No. 3 has to be replaced by the new
5.
incumbents.
5. 4 and 5?
Yes, 4 and 5, my lord. 4 was the respondent Director General, the former Director Doordarshan Kendra, and due to transfer of the
So, Ms.
said
Sangpui,
person.
you are appearing for? 4 and 5. Say 4 and 5. By way of this application, the applicant is seeking striking out the names of Priya Kumar, respondent number 2, and Shri Surinder Singh, respondent number 3, from the arraignment of parties in the accompanying contempt petition, contempt case civil number 15 of 2024, and for impleadment in their place, Shri K. Satish Nambudripad, the Director General Prasar Bharati Doordarshan, as respondent number 2, and Shri Ramesh Singh Chauhan, the Deputy Director Admin Prasar Bharati Doordarshan Bhavan, as respondent number 3 in the said contempt case number 15 of 2024. Paragraph page 6 of Pama. It appears that at the time of filing, that during the filing of the contempt proceeding, the applicant inadvertently arrayed Srimati Priya Kumar as the Director General Prasar Bharati Doordarshan Bhavan, though she was not holding the said post at that relevant point of time. In fact, she is holding the post of Director General News. Likewise, Shri Surinder Singh was also inadvertently arrayed as respondent number 3, allegedly being the Deputy Director Admin Prasar Bharati Doordarshan Bhavan, though he was not holding the said post and instead was holding the post of Deputy Director General Admin. Accordingly, it appears that the aforesaid 2 respondents have been wrongly arrayed as respondent number 2 and 3 respectively in the accompanying contempt proceeding. It further appears that the competent authorities for complying the direction passed by this court in WPC number 96 of 2022 being Shri K. Satish Nambudripad, holding the post of the Director General, and Ramesh Singh Chauhan, holding the post of the Deputy Director Admin, are required to be impleaded as respondent number 2 and 3 for effective adjudication of the instant contempt proceedings. Accordingly, the prayer for striking out the names of Shri Priya Kumar, Srimati Priya Kumar, respondent number 2, and Shri Surender Singh, respondent number 3, from the arraignment of respondent stroke contemptor in contempt case number 15 of 2024 is allowed. Resultantly, their names be struck off. Let Shri K. Satish Nambudripad and Shri Ramesh Singh Chauhan be impleaded as respondent number 2 and 3 respectively in the connected contempt case number so and so. Let an amended cause title be filed before the registry for doing the needful. Allowed.
Deeply obliged, Your Lordship.
In the contempt case, you may say that let the same be listed upon furnishing of the amended cause title
My Lord.
on a date to be fixed by the registry. Yes, ma'am. Okay. Mr. Lal, I think Mr. Lalram Zava, we can have the hearing, but can I just have a 5 minutes break before we start? Huh? The other side is there in your matter. Miss Linda, you are appearing.
Hearing list, item number 4.
Yes, Mr. Lalram Zava.
Lordship, though I had earlier stated that we intend to withdraw the instant appeal, since the Lordship had expressed the Lordship's opinion that it is not having any link with the early acquisition. The Lordship, in that regard, that is the very foundation of our case also. What I have been saying is that since the land of the appellant was even earlier investigated and found to be surely to be submerged, but during the course of acquisition, the matter was not properly investigated, and only some few of his teak trees were found to be within the submergence area. Subsequent developments, if I take a Lordship to the paper book at page 29, page 29, Your Lordship.
Just before that, section 9.
Yes.
CPC, the court shall have
Subject to-
jurisdiction to try all suits of a civil nature, excepting suits of which their cognizance is either expressly or impliedly barred.
Yes.
Right? So this is why, if suppose it is a part of that award, then you have the reference under section 18,
Yes.
then it becomes barred. Correct?
True.
So for that, there has to be a case that this is part of that award. But if it is not part of the award, then how do you link section 9? Because then you can't go for reference. This is what came to my mind. Because I saw you had taken this ground, Mr. Lalram Zwaba.
That's true.
That ground is there in your appeal
Yes.
memo. I read your grounds. So that is how I mean, we don't know. Let us see if, perhaps You wanted to show something, yes?
Your Lordship, since we had unsuccessfully tried to make a reference even earlier, but because of the delay, it was
That I have
time barred.
seen.
Yes. And thereafter, developments took place and the matter was reopened.
But you say reference is for what? If you are not accepting the award,
Yes,
so that means it has to be part of the award.
that's true.
So
But
this
it is, the land is contiguous.
correct.
Land is contiguous.
Land is contiguous, but what is there in the award? Whether the 8,366 teak
That-
trees alleged to be submerged due to Sarlui B
Sarlui B.
hydroelectric project. That this is the main thing, isn't
That
it?
is the main thing.
So, if I have understood the facts correctly, the appellant owns a garden under a VC pass.
Yes.
What is the VC pass called?
One of 1983.
No, what is VC?
VC, Village Council.
Village Council.
Village Council pass.
Village Council pass. And you had, and the appellant had cultivated teak trees in,
Teak
in
trees,
this land,
yes.
and claims that 8,366 trees survived until the project submerged.
Yes.
Correct?
Right.
Now, the award pertains to the projects but assessed only 1734 teak.
Yes,
Correct?
right.
Now, this award is dated what? Can I have the date of the award?
Date of the award is at page 12, Your Lordship.
You just give me the date of the award.
It is award number 3 of 2004.
Or
It is
at page 12, you are right. It is at page 12 to 22. Is there a date there? Yes, Mr. Stephen?
Your Lordship, date has not been given in the award itself, but
But it has to be, because this inquiry commission is 26/110. This is subsequently, right?
Inquiry Commission,
Now,
yes.
this found that 6,632 additional teak trees
Yes.
belonging to the appellant were left unassessed.
That's true.
Correct? And I don't think Miss Linda, you don't dispute this position.
Which one, my lord?
You don't dispute the inquiry report.
The inquiry report, my lord, we have no knowledge regarding the terms of reference. The department does not know about it.
No. Are you disputing the inquiry report? You
Yes,
have
my lord,
you have
because-
not disputed during trial. Where have you disputed?
My lord, we have stated in our affidavit, my lord, the terms of reference of this volume inquiry commission is not known by the department at all.
No, you are saying you don't know the terms, but you are not disputing it. Where have you disputed the trial that report in the cross examination? Have you disputed? Because the trial court have accepted it as credible but dismissed the suit only on jurisdiction. You are not disputing.
There
You
is,
saying that you
my
do
lord,
not know the terms. But you are not
But
disputing.
on what basis has this commission
Correct,
been
that is
carried
different.
out?
But you're not disputing. You are not disputing the existence. You have never challenged this inquiry report.
They have made the inquiry report, no doubt. my lord.
Correct. That's
But
what I'm
the
saying.
validity,
See,
the terms
now
we are
this
not-
being an appeal, according to me, the issues that falls for determination in this appeal, number one is whether the civil court's jurisdiction was wrongly rejected. This is number one. Number two, if whether the appellant has established a factual basis for compensation.
Yes.
If so, it requires adjudication, right? Now, whether in this situation this court will look into or remand the matter back for that limited purpose. I think briefly these are the three issues.
Yes.
As far the first issue is concerned, without going much into the depth of the matter, if this court is satisfied that this 6,632 additional teak trees was not part of the award, then what remains? then how can a reference be made? Where is the question of the applicant being aggrieved by that award and not accepting and seeking a reference on this point? Because 6,632 was not part of that award. And you have never challenged the subsequent inquiry commission's report. You have not. Till date, you have not. You may not know the terms of the reference, Miss Linda, but you have not. And let's see the trials court order, Mr. Lalram Zaba. I have a feeling even the trial court have said that they they have accepted the credibility of this report. I remember reading somewhere.
Yes, yes, Your Lordship. If I take a Lordship to
Yes. Where do I find the judgment?
284,
284, yes. Let's see.
at page 284, with regard to sub-issue 1, whether there actually is 8,366 number of teak trees at the relevant point of time in the land of the plaintiff covered by the VC pass number 1 of 1983, located at Builum.
Yes, please read that.
It may be seen that at para 2 of the plaintiff averred that there are 8,366 teak trees in his land, hereof, which survived out of the 9,000 planted by him. And at para 15 and 17 of the plain, he averred that as per the findings of the
Come
said Builum
down to
Inquiry Commission.
subparagraph. And as already observed by this court
Yes.
at issue number 1,
Yes.
this report has not been objected by the defendants, either in their written statement or during evidence also. Ms. Linda?
And the same also.
And the
apparently-
same also apparently partakes the form of a public record. Besides, despite the evidence of the defendants that they had assessed every teak tree lying within the water level so and so, they however did not counter the report of the Bullion Inquiry Commission, which was much later in time, and also did not raise any doubt thereof. So hence there is no further choice but to take the said number of excluded trees mentioned so and so as a fact and adding the same with the number
Teak trees
of
actually.
so and so.
Yes.
The total so and so, so and so. Therefore, one is found to be in the affirmative and then comes to 2. But this was not a part of your award.
That's true.
This is subsequent.
Yes, subsequent. And the Builum inquiry was constituted by the government, and it had taken a full-fledged inquiry, and with all this, but the same was submitted to the government, it was accepted, but no action was taken on the basis of that report. That's why we have filed the instant suit also, for the purpose of implementation of whatever finding that was there, particularly in respect of the land of the plaintiff. As the Lordship had observed, the earlier proceeding was a closed chapter. We had tried to reopen it, but we had failed so miserably because of the delay. Delay could not be condoned as per the ruling of the Supreme Court also. That is a closed chapter. But since the government had taken a fresh step, even before that, the core committee had taken up the matter, and the office of the chief minister had taken initiative. They had made certain recommendations.
I don't think we need to go into all that.
That may not be necessary.
No need to.
Subsequent to that, Your Lordship, this Builum Inquiry Commission was constituted.
That is important.
So it is far apart from that of the award, but 3,004.
One second, huh? This is a decision of the Apex Court in the case of Lakshmi Chand, which is reported in 1996 7 SSC 218. Now, it says, it is seen that Section 9 of the CPC gives jurisdiction to the Civil Court to try all civil suits unless barred. The cognizance of a suit of civil nature may either expressly or impliedly be barred. The procedure contemplated under the Act is a special procedure envisaged to effectuate public purpose, compulsorily acquiring the land for use of public purpose. The notification under Section 4 and declaration under Section 6 of the Act are required to be published. The inference gives conclusiveness to the public purpose and the extent of the land mentioned therein. The award should be made under Section 11 as envisaged thereunder. The dissatisfied claimant is provided with the remedy of reference under Section 18 and a further appeal under Section 54 of the Act. If the government intends to withdraw from the acquisition before taking possession of the land, procedure contemplated under Section 48 requires to be adhered to. So here, according to me, the ratio laid down by the Apex Court is that civil court jurisdiction is barred only where any land property has actually been included and assessed under the award. Now, this particular trees were not part of it.
The portion which has not been included in the words, those trees are standing.
Those are standing.
Yes.
Then there is another decision similarly. Let us take the award once. Page 12.
That's it.
Which is the portion which you are, it is in respect of you.
We have enclosed here compensation statement for the building, crops, etc. Lordship, since the land which is within which the plaintiff appellant had cultivated his teak tree is not within, under LSC. It has not been shown in the list. Market
not
value,
there.
market value of the land was not given.
So that is not there.
That is not there. But however,
What
Your
was
Lordship,
there?
and the compensation statement for crops at
Yes.
page 16,
Yes.
the name of the appellant, Light Warmer, teak,
At page 16.
at page 16, yes.
16. No, the award finishes at page 15.
Yes, award comes to a close at page 15. The annexes to the award.
Now in 16, what is there?
16 is the assessment in respect of crops and buildings.
Lal Thuama,
Light Tuama,
that is the petitioner.
petitioner.
And Teak,
Yes.
1734.
1734. And Kuva. Kuva means betel areca nut.
Erica.
Yes.
So 1734 only.
1734 teak trees and betel tree 2987. So the total comes to 4,114,950.
Yes.
And at page 20, Lordship will see.
Now you had already approached the reference court once, isn't
Yes,
it?
yes.
But that was dismissed
Dismissed.
for ground
it
of
was rejected.
limitation.
Yes, limitation.
Limitation.
Yes.
Then you had come before the High Court. And
Yes.
High Court had given liberty.
No, we had approached the High Court challenging the view, the decision of the district collector,
Rejecting the condemnation.
Yes.
And then
Then High Court said that there is no condonation, no condemnation provision is there. So the matter ends there. And thereafter, we had filed another writ petition for the purpose of constitution of an inquiry commission. That was not done earlier.
later it was done. Later it was done.
Yes.
Ms. Linda, I think to be all fairness, I don't want to go too much into the details because then it might, I do not want to unnecessarily narrow down the scope of Section 18 also, right? But what it appears is that the 6,632 teak trees have come out only subsequent to the Inquiry Commission's report, which appears from the trial court's order that the said position was not disputed by the defendants during trial. That being so, that is not part of the award. So I will send the matter back to the trial court on remand and ask the trial court to adjudicate on the part of that determination. This is the approach I am going to take.
Your
All
Lordship,
right.
with that, I'll have to object on that.
Yes, yes, that is why I am hearing you. You give me your objection. That is what I am hearing you. Now I hear you. I'm indicating.
Yes, I understand.
Yes. So you show me if you have objected. The trial court order you have not challenged. Have you challenged the trial court order? We read the trial court order.
Which trial court order, madam?
The judgment. The judgment which we just read in this case.
Regarding the Bulum Inquiry Commission.
No. Where is that page? Page 23. Against which this RFA is filed. Come to page come to page 285. This RFA is filed against this judgment, isn't it, Mr.
Yes.
Yes. You read. For your satisfaction, you may read from page 284, sub issue 1. And then you give me your objections. Because your objections has to be based on, we are hearing a appeal. It has to be based on evidence and materials. It has to come out from the records.
First of all, my lord, I'd like to state that the basis itself is not correct. My lord, first of all, VC cannot allot the garden pass. And the pass which the applicant
Miss
has
Linda,
held-
we are not challenging. This is not a writ petition. This is not a writ petition.
My lord,
Are you challenging the trial court's order?
we're not challenging.
Then
We're
you
not challenging,
confine,
and in fact,
you see,
my lord,
you have to confine your arguments as a defendant in this case.
my lord, in fact, we have, the trial court has rightly rejected.
So you say whatever you want to say in that
Because
support.
the cause of action relates back to award number 3
Okay,
of 2004.
fair enough.
Yes, because, my
Yeah,
lord, the
fair
award
enough.
number 3 of 2004 talks about the number of teak trees.
Very well.
And this award was made after spot verification was done. But later only, my lord, subsequently only, the
Very well.
appellant, they have received the award under protest. And
Very well. Noted. And
my lord, the reference was also rejected by the trial court.
very well.
And the High Court also confirms the rejection.
Very well.
Now, again, my lord, the civil suit was filed to again assess. So the question is whether if this is maintainable or not.
Very well. Noted. I'll deal with it. I may hold it in your favor also.
Yes, ma'am.
Yes.
So my submission is that the whole case relates back to this award,
Award.
number 3 of 2004.
Very well.
Because it relates to the amount of teak trees and areca nuts.
Very well.
And nothing else. And my lord, with regard to the Builum Inquiry Commission, we have submitted our written statement wherein we have stated that terms of reference is not known. So
Is not known. Okay.
Yes.
Yes. Yes. That's all?
That's all, my lord.
Okay. Mr. Lalram Zwaba, in the event this court thinks of remanding, it will be under Order 41, Rule 23. Please have your water. Have your water. Please
Thank
have
you.
your water. Miss Linda, you also see that? Because here it was on a preliminary point the suit was disposed of, right? I'm correct? Just check that portion, that portion of the impugned judgment. I think 23A will be attracted here. Isn't it?
23A. Yes.
Because I think it is both on merit and jurisdiction at the end. There was no preliminary point issued. Isn't it? Just see that.
Where the court from whose decree an appeal is preferred has disposed of the case otherwise than on a preliminary point, and a decree is reversed in appeal, and a retrial is considered necessary.
Down on me because the grip, it's too close and it doesn't go back also. Anyway. Yes.
The appellate court shall have the same powers as it has under Rule 23. Rule 23 is regarding remand of a case by appellate courts. Should I read the Lordship?
No, it's okay. All right. Heard Mr. Lalram Zwaba, learned senior counsel, assisted by Mr. Stephen Lal so-and-so, learned counsel appearing for the appellant. Also heard MS Linda, learned, you're appearing as Additional Advocate General of the state of Mizoram. This appeal challenges the judgment and order dated 25/10/2019, passed in civil suit number 3 of 2011 by the learned senior judge,
Senior Civil Judge.
Senior Civil Judge 2, Kolasip District, Kolasip, whereby the plaintiff's suit for compensation of 8,366 teak trees alleged to be submerged due to the Surlui B hydroelectric project was dismissed for want of jurisdiction. The facts of the case ये 3.1 और पूरा ये यहाँ पर तुम ले लो हाँ हाँ ये पर से पूरा 3 point paragraph 4. Accordingly, the trial court framed the following issues. Para 5, page 301. Or can you 293 prapaba? The trial court, while accepting the finding of the William Inquiry Commission, Report 2010, nonetheless dismissed the suit on the ground that civil court lacked jurisdiction and directed the plaintiff to pursue the remedy under the Land Acquisition Act 1894. Aggrieved by the aforesaid judgment, the present appeal has been preferred. Mr. Lalram Zwava, Learned Senior Counsel, submits that the trial court had illegally decided issue number 3 against the plaintiff by holding that it was devoid of the mandate as well as jurisdiction to grant relief claimed by the plaintiff. He submits that there was no issue framed by the trial court as to whether it had the jurisdiction to entertain and adjudicate the suit. He further submits that it is evident from the reading of the trial court judgment that the parties where that the suit was decided on merit after hearing the maintainability of the suit on 21/2/2013 was decided to proceed was decided to proceed hearing on the merit after deciding the maintainability of the suit on 21/2/2013. He further submits that though the genesis of the 8,366 teak trees of the plaintiff was not part of the award number 3 of 2004, as the same was subsequently found by the Bullion Inquiry Commission final report, the said issue cannot relate back to the said award number 3 of 2004. He further submits that under section 18(1) of the LA Act, any person interested who has not accepted the award may, by written application to the collector, require the matter to be referred by the collector for the determination of the court whether his objection to the measurement of the land, the amount of the compensation, the person to whom it is payable, or the apportionment of the compensation among the persons interested he submits that, however, in the present case, since the suit filed by the plaintiff is based on the findings of the Bullion Inquiry Commission final report and not on the compensation awarded to him by award number 3 of 2004, the conclusion of the trial court that the grievance of the plaintiff was apparently within the sole purview of the reference court is totally erroneous and perverse. He further submits that this court, by judgment and order dated 24/7/2008 in WPC number 13 of 2008, had given liberty to the appellant plaintiff to approach the competent court of civil jurisdiction for his redressal if so advised. And hence, the trial court could not have concluded that it was devoid of the mandate as well as jurisdiction to grant the relief claimed by the appellant plaintiff. He further submits that the trial court has failed to consider the fact that the suit filed by the appellant plaintiff was based on the findings of the Bullion Inquiry Commission final report dated 26/1/10 and not on the award number 3 of 2004. Per contra, MS Linda submits that the grievance raised by the plaintiff in the instant suit clearly relates back to the award number 3 of 2004, and hence the same is barred under section 9 of the CPC. She further submits that the appellant, instead of adjudicating the grievance before the reference court under section 18 of the so and so act, has filed the instant suit, which on the face of it lacks jurisdiction to try the same, and hence the judgment of the trial court dismissing the suit for want of jurisdiction warrants no interference from this court. Correct? I have given my prudent consideration to the arguments advanced by the learned counsels appearing for the parties and have perused the materials available on record. It appears that the appellant owns garden land under Village Council Pass number 1 of 1983 at William Village. It is further apparent that the appellant cultivated teak trees on this land and claims that 8,366 trees survived until the project's submergence. It further appears that the award number 3 of 2004 pertaining to the Sir Louis B project assessed only 1,734 teak trees of the appellant. It is further apparent that subsequently a state inquiry commission, by its final report dated 26/1/2010, found that 6,632 additional teak trees belonging to the appellant were left unassessed. It appears that the respondents did not dispute the inquiry report during the trial. The trial court also accepted it as credible but dismissed the suit solely on jurisdiction. Apt to refer to the relevant paragraphs of the judgment of the trial court in this regard, which reads as under, quote unquote. 284 for a paragraph A, B, C. Till 286. A, B, C heading as a quote unquote. The following issues arises for determination. Number 1, whether the civil court's jurisdiction was wrongly rejected, whether the appellant established a factual basis for compensation regarding adjudication, whether remand is proper. As regards the issue number 1 relating to jurisdiction, it appears that the trial court held that civil court jurisdiction is barred because the grievance relates back to award number 3 of 2004. This finding appears to be contrary to settled law. In Lakshmi Chand versus Gram Panchayat Kararia reported in 1996 volume 7 SSE, the apex court has held that civil court jurisdiction is barred only where the land property has actually been included and assessed under an award. In short, where property is omitted from the award, civil suit remains maintainable. It is an admitted position that no award exists for the 6,632 teak trees, and thus Section 18 of the Land Acquisition Act remedy was unavailable. The statutory framework cannot bar civil court jurisdiction without a statutory alternative remedy being available. I am of the opinion that omission of the 6,632 teak trees give rise to an independent civil remedy. In fact, this court in WPC number 13 of 2008 by judgment in order dated 24/7/2008, upon being approached for compensation in respect to the aforesaid acquisition of for aforesaid damage of trees of 6,000 the damage of 6,632 teak trees, this court had given liberty to the appellant to approach the competent court of civil jurisdiction for his redressal, if so advised. In view of the aforesaid liberty given by this court, the present suit has been filed. Correct? This is the correct position.
Yes.
Be it as it may, Section 9 bar applies only in respect of matters covered by an award. Hence, the trial court erred in concluding that Section 18 was the exclusive remedy. Issue number 1 is answered accordingly. This court therefore set aside the finding that the suit was barred for want of jurisdiction. Now turning to issue number 2, as regards whether adjudication on merits is necessary, it appears that the trial court has already accepted the Inquiry Commission Report 2010, which the appellant relies heavily to establish that 6,632 trees were omitted. It further appears that though the trial court accepted the aforesaid factual contents of the report, however, refused the relief thereof. It is thus apparent that the trial court did not adjudicate proof of ownership, plantation basis, enumeration accuracy, valuation as per the 2011 notification. These issues requires fact finding. Ordinarily, where evidence is incomplete or factual issues remain, remand is the proper course. Though the trial court heard the matter on merit, however, decided only jurisdiction and did not return findings on factual aspects, I am of the unhesitant view that to avoid prejudice to either party, remand for full adjudication is the correct approach. Hence, the omission of 6632 trees from assessment has prejudiced the claimant The respondents cannot invoke Section 18 to defeat the plaintiff's claim where their omission made the remedy unavailable. Accordingly, I am of the firm view that the trial court erred in dismissing the suit for want of jurisdiction. Material factual issues remains to be adjudicated. Therefore, remand is necessary. Resultantly, the judgment and order dated 25/10/2019 passed in civil suit number 3 of 2011 is set aside. The matter is remanded to the trial court for fresh adjudication on all issues on merits. Return the TCR. I don't think I should say a particular, it doesn't.
Timeline.
Isn't it?
We'll make necessary pressure, Lordship.
Sorry?
We'll make necessary pressure because it has been long pending.
Correct.
Matter has been.
Because I think we should allow the trial courts also to have their own flexibility, isn't it? I may add few more decisions. I had taken down few decisions. So let me just have a look at them. I will edit it. I just wanted to pronounce it in court in your presence, the facts and the concluding. So I'll edit it. You may not get the copy today itself. Huh? So by tomorrow you'll get it. All right?
Highly obliged, Your Lord.
So we done? Let's see, keep inside.